morning and welcome back to the podcast. I'm SandiWarner with Warner Realty Group. If this is your first time listening to our podcast, this is a series where we sit down and talk to experts in the field, specifically some of the attorneys over at Sayer Regan Thayer in Newport, and we talk about the craft and the legal aspects of real estate. If you haven't listened to us before, give us a thumbs up if you like this content, subscribe so that you get notified anytime we put out a new video, and hit that bell so that you get notified. Today, we're going to talk with Melissa Green over at Sayer Regan Thayer, and she specializes in estates and taxes over there. And the question we had for her today was, what happens if we have a listing and we find out, because remember, anytime you take a listing or anytime you're working with a client, part of your due diligence is to find out who can sign. And if in the course of you go get a new listing and you look it up in the tax assessor's database and you find out, hey, Sally Sue is not the owner of record, it's actually the revocable living trust of Sally Sue formed in 2017. Well, that needs to send off a signal to you that maybe you need to do a little bit deeper work. So Melissa is going to help us talk about what are the signals that we should look for. So please join me in welcoming Melissa Green from Sayer Regan Thayer. Hi, Melissa. How are you today?
I'm well, Sandi. How about yourself?
I'm good. Are you excited to talk to us about this scintillating topic?
Oh, very excited. I appreciate the warm welcome and introduction there, Sandi. Melissa Green from Sayer Regan Thayer over on Bellevue Avenue in Newport. Happy to chat with you today, a little bit about real estate and a little bit about trust and estate planning as well.
Fantastic. So specifically today, we're going to talk about more sellers. We're filming this in the fall of 2022 after the big market shift in June and July of 2022. And we're seeing some more sellers willing to put their homes on the market. So if an agent is talking to a seller and they do their due diligence, we're going to say that again, find out who can sell, and they find out that it's a trust that owns this property, what are some tactics that a listing agent should have in their toolkit to make sure that they're talking to the right people and they're writing agreements the right way?
All right, so perfect question. I guess, preemptively, the way to check and find out who the owner of a property is to take a look in the land evidence records and find the deed into the current owner. So Mary Smith or John Smith calls you, says they want to sell their property at 1234 Main Street. You go to Rhode-IslandLandRecords.com and you can find a link to the recordings, the registry of deeds for each of the municipalities. You pull that deed and you find out that Mary Smith owns that property, but in her capacity as trustee of a trust. Well, what does that mean to you as the agent selling or assisting this seller? Or what does that mean for you if you're a buyer or a buyer's agent looking to purchase this property? So what is a trust? First of all, would be helpful to understand. A trust is just simply a contract, an agreement, a piece of paper. So a contract is, or a trust is a contract between two parties, a grantor, settlor, the party establishing the trust, and a trustee or trustees who have entered into an agreement to hold whatever is owned by that trust pursuant to a set of instructions within the trust document. So if you think of a trust like a bucket, whatever you put in that bucket, trustee owns, but they have to follow the instructions within the trust document. So if a property is owned by a trust, how do we determine who the seller is and do they have the power to sell that real estate? Seller of the property, if it is owned by the trust, is going to be the named trustee within the document. You can take a look at that agreement, try to figure that out yourself. Your client probably knows that, or you can bring in an attorney to take a look at the trust and give you the definitive answer as to who the seller is, who's the trustee, and do they have the authority to sell real estate? So kind of two big differences here when you're selling property from a trust. First of all, the trustee can only sell the property if the terms of the trust actually say that. You, trustee, have the power to sell real estate, and is that conditional or unconditional? Do they have full discretion to sell the property? Or is that contingent on something like a right of first refusal? First must be offered to a beneficiary of the trust. Or do the trustees have to be directed by the beneficiaries of the trust? Some trusts say trustees can't act. They can sell real estate, but they can't do so until they've been directed by the beneficiaries. So first sort of difference is, do they have the power to sell, and are there any contingencies that need to be met before they go ahead and list that property and sell that property? Second kind of primary difference between your normal individual sellers and your trustee is that fiduciaries, trustees, are exempt from seller disclosures. So the law says fiduciaries, trustees, executors, guardians have no duty to disclose, no requirement, with the exception, by the way, of lead disclosures, to give seller disclosures when they're listing a property. Well, what does that mean for you as the seller's agent? Is this a great opportunity? Not necessarily. When I'm working with clients, I'm often saying, seller, be wise. Is it really wise to fail to disclose something that you know about this property, something that's going to come up in the inspection during the inspection period and kill the deal anyways, or cause a second round of negotiations? It isn't always prudent to take advantage of that exception to the disclosure law. So seller, be wise, talk to your agent, talk to your, attorney about that, and buyer beware. If you are purchasing property from a trust and the trustee isn't giving you seller disclosures, extend the inspection period, take further time to do this due diligence that we're talking about. Agent, go out to the city and town halls, check the zoning records, the building inspection records. Make sure you're taking the appropriate time to do your due diligence if you don't have seller disclosures to rely on. So I think that's primarily the two differences that should go off as sort of, flags in the agent's head if they learn that they're going to be representing a seller who is a trust.
So if a listing agent goes and talks to, Bob Smith, and Bob says, oh, it's in a trust, should the listing agent hold off on signing any listing agreement until they talk to an attorney? What would that timeline look like?
So usually, well, certainly, if a property is in a trust, an attorney's been involved at some point. So it's often as easy as a quick 5-minute phone call to the attorney. You'll find the majority of the time, the type of trust that we're talking about that owns real estate is a standard revocable living trust. There are tons of people out there in our community who own property in revocable living trust. They are a very common estate planning tool. They act kind of like a glorified will. They've got some benefits, avoidance of probate, and other benefits to them. But generally speaking, your trustee, your grantor, your owner, John Smith, are all the same people. That trustee pretty much has full discretion to manage that asset as if it was in his or her own name. And they probably know that. And most times you can rely on your client if they are very confident this is a standard revocable living trust. But really, it's a matter of a quick 5-minute phone call to the attorney if there's any question about it.
Is there a specific way the name has to be written if it's a trust?
That's an important question. There is, to ensure you've got a legally enforceable listing agreement, eventual purchase and sales agreement, deed conveying the property. Once we get to the closing table, you need to identify your seller appropriately, which is name of the trustee, capacity, trustee, and the name of the trust. So for instance, standard revocable living trust, John Smith, comma, trustee of the John Smith Revocable Living Trust, dated September 29th, 2022. So that's how your seller should be identified. The name, capacity, and the name of the trust is the proper way to name the seller if it is owned by a trust.
And what if it's a, are there red flags? Are there certain trusts that we could say, oh, that you definitely, we definitely need to talk to someone? Are there specific trusts that are common enough that it's worth sharing? Hey, look, on this one, your guy probably can't sell it.
So not necessarily that they can't sell it, but there might be other things to think about, reaching out to a CPA and saying, are there going to be some tax consequences we need to be prepared for based on the type of trust that we have here? Or are there complications with, beneficiaries that need to be involved here? Or are there, protections in that trust that we need to ensure we don't pierce through? Like, is this type of trust that was put in place for purposes of protecting assets from nursing home expenses, long-term care expenses? Well, if they are, you've got to be very careful about the way the proceeds are held post-closing. So there are enough different types of trust out there that it's always prudent to get ahead of it and find out. I think the majority of the time that you'll find that it is no different obstacle than a normal sale, but it's certainly prudent because trust can be set up for tax purposes to minimize or avoid certain taxes, or to protect assets from exposure from third parties like creditors, nursing homes. And so you don't want to be the cause of, causing an issue with one of those benefits that's been provided. So certainly something you want to consult with your client with, talk to an attorney, CPA with prior to selling the property.
Very good. Fantastic. Melissa, is there a question about selling trust that I didn't ask you that I should ask you?
Is there a question about selling assets from a trust that you should have asked me? I can't really think of a question that you should have asked that you haven't. I think it's prudent to make sure that you have a team of advisors that are working cooperatively together on all transactions. But of course, that's sort of heightened when you've got trust in place, because it's hard for you agents to know why was this trust put in place. And so having sort of your trifecta of your real estate agent, your CPA, and your attorney all on the same page is helpful to your client. Yeah. Certainly, that sets the most appropriate plan moving forward and protects you. It makes you not responsible for giving legal advice or talking about tax consequences. Defer that to the appropriate professional, and you've set the expectation appropriately. You've done your job by doing so.
Yeah. And I think particularly for newer agents, it's really hard, I think, to understand how to divide your responsibility. Your responsibility really is find out who can sign. You need to look up the deed, or you could go to the tax assessor's office. Make sure you know how this property is titled. Right. And if it's anything other than the person that you're talking to, you need to take extra steps. It does not mean you need to understand why a trust exists, or you just need to know, hey, I need to ask more questions.
I need to ask more questions. Yep. I need to find out if there's any additional steps that I need to take. Yes. Do I need my client to work with their attorney to offer this property to somebody else because the trust says that? Do I need to, file any additional paperwork with the IRS or, the taxing division in any particular state in advance of closing or post-closing? So it's an opportunity to ask questions, make sure you know what you need to, but otherwise, I think you shouldn't be scared away by it. It's all over the place, all over. We deal with it all the time. It's no real obstacle. Just make sure you're doing your due diligence by, getting the right professionals involved, and then giving your clients the best benefit by doing so.
Exactly. So Melissa, if an agent was out there and they ran into a trust and they wanted to get your advice on this, how would an agent get in touch with you?
So easiest way, give me a ring up at Sayer Regan Thayer, 401-849-3040. Also, email works fantastic in 2022, of course. Email is M as in Melissa, green, just like the color, at S as in Sam, R as in Ralph, T as in Thomas, -law.com.
Fantastic. And you're okay with just sharing advice with the membership?
Absolutely. Absolutely. Happy to help.
And for any of you that are watching, Melissa does teach a class at NCBR And I think it's called Trusts and Estates, isn't it?
It is real estate and estates. And so it's talking about buying and selling real estate from an estate. And sometimes that's a trust, but also talking about probate estates and otherwise, and what additional steps might be needed if you've got a decedent owner in a probate estate. So happy to entertain you, hopefully, in that class as well. Love to see you all there.
Fantastic. So if you are working with, if you are a new agent, obviously you've now just met Melissa Green. If you haven't met her before, she's with Sayer Regan Thayer. You can email her. We'll make sure all her contact information is here. You can go and take her class. And I think particularly if you're dealing with a particular generation of seller, this is something you might want to specialize in. And this is a large group. This is the boomers moving through and Gen X moving through, who have taken steps to protect their property, especially if they've had some, any kind of financial success. So it's something to add to your toolkit. It's another arrow for your quiver of how to prevent stress during your transaction, because you're looking for these things up front and you're not getting, signed documents over to the closing attorney 2 weeks after you've gone under contract and find out, whoa, you can't sign. So do your due diligence, ask for help when you need it. Utilize all of the great contacts that we provide for you. I'm SandiWarner with Warner Realty Group. Don't forget to subscribe to our channel. Hit the button, give us a thumbs up if you like the content, and hit the bell so you get notified when we put out new content. Have a great day.